Call to order the Board of Adjustment meeting for February the 16th of 2012. This time, I'd like to remind you to turn off your cell phones. First order of business is the approval of minutes of the February 2nd, 2012 meeting.
Move to approve.
Second.
Have a motion and a second. Register your vote. The minutes are approved. Continuance requests or withdrawal requests from staff.
We have three today. Item number 7, case number 13507, is asking for a continuance to March 1st. Item number 8, case number 13518, is requesting to be withdrawn. And item number 10, case number 13447, is asking to be withdrawn.
I'd like to hear a motion on case 13447 first, please.
The one that's on the agenda,
Yes.
Item number 10.
Yes.
So move.
Second.
Have a motion and a second. Register your vote. That is withdrawn. I'd next like to hear case number 13517, case number 6, which is also a request to be withdrawn.
Move.
It's item number 8, 13518.
Mr. Chairman, is there anybody here that's...
I apologize. I did not ask the question. On case number 13447, is there anybody from the public here to address that issue? Case number 10. Okay. Did I stand corrected? It's case number 8. Okay. Case number 8. 13518 to be withdrawn. Do I have a motion?
So move.
Second.
Register your vote. Case number 13507 is a continuance request to March the 1st, and for that case I would ask, are there anybody present from the public that's here to speak on that case? The first speaker I have is Randy Ice, if he would approach, please. Your name and address for the record, please.
Randy Ice, 119 Northwest 19th Street. I'm president of the Heritage Hills East Neighborhood Association where this is occurring.
And what I'd like for you to address is whether you protest this continuance request to March 1st.
Yes, I protest it.
Okay. Thank you, sir. My next requested speaker is Debbie Blackburn. And if you would just tell us whether you speak in favor of or in protest of the continuance request to March 1st.
Continuance.
You protest the continuance request. Thank you. And my next requested speaker is Bernadine, please, Madole. Thank you. And would you favor a continuance to March 1st, or would you not favor that?
I would not favor that. I protest a continuation.
Thank you. Board members, do you have any input on that continuance request? We've got...
I'd like to hear from the applicant why he
Please.
wants to continue.
Okay.
Hi, Dave Ledbetter. I'm representing both the owner of the property and the developer of the property. They both request a continuance so we have time to develop a program to present the proposed operator of the facility, which is the food service, and the talent of the facility, which would be the entertainment involved. And I think after we're able to disclose the entities involved, everything will be, I think you'd be much more agreeable to our proposal.
Is there a reason that you didn't come prepared to do that today?
They are not able, in the entertainment industry, there are certain disclosures that it can't release until all the documents are signed. And there's certain, I'm under a non-disclosure agreement right now. I can't disclose the proposed operator, or excuse me, the proposed entertainment. And they would like to have, the time frame to put together a proposal, call the members of the various organizations in, have an open meeting at the job site or whatever venue they request, and be quite happy to explain at that point.
It's obvious there are concerns from the neighborhood,
I quite understand.
and you expect that a continuance would allow, your developer, your owner, or whoever to
That's what they requested, yes.
address those concerns. And the nature of the clarification would be in the type of entertainment?
Correct.
And what else?
The food service operator, the level of the food service provided, the type of operation in its entirety.
Well, I think, the building plan that you provided us in our packet tells us a lot about the kind of venue that it's going to be. Am I correct?
It's going to be a restaurant that does have live entertainment.
I know I wasn't in attendance, but I watched the recording of the meeting where you characterized it as a family-style restaurant.
I believe the entertainment would be agreeable to its family style. The proposed artists are in top 10, either in the country music or in the general.
And I don't know that it matters to the neighbors or that it would matter to me whether it was, a country style or some other style of entertainment. What I see is a lot of places, bar stools next to a rail that are not there for dining. They are there, for serving drinks, and which tells me that, that there's a lot of opportunities for people not to come and eat, but of people to come and be entertained or to participate. There's a dance floor, a performance stage, and a lot of rails and bar stools on the main floor and the mezzanine.
Yeah. By code, they're limited to ABC2, which defines it has to be a restaurant that serves alcohol.
Is this request just for to reduce the amount of parking? Is that all it's about? It's not about the ABC2?
No, it's not about the ABC. We have an existing structure which is approximately 9,000 feet. We're required to have slightly over 90 parking spaces. There are 65 to 70 available on site as it is now. So we're requesting to...
The item on the agenda is strictly for
For
parking?
parking only.
Okay.
We have another hurdle to go with ABC.
And I think, you'll see in your packet that there are protest letters from adjacent businesses and neighbors that have concerns. And again, what happens inside the building, it appears to me that there's, there are a lot of opportunities for, not only dining, but, a bar-type facility. And just the number of people, coming out in the evening after having been in this venue is, I can't help but think that it's going to be disruptive.
And the adjacent parking lot is fully valet. We have total control over it. The owner has disclosed that they intend to have security. Security will be no less than 3 off-duty police officers. They have a contract with the FLP, and to my knowledge, it would be the Nichols Hills Police Force that would be patrolling this lot.
The other thing I'd like for us to consider today is that we have, residents who've taken the time and gone to the trouble to attend today's meeting and taken, time out of their day. So, my preference would be that we go ahead and hear this today.
I make a motion that we hear the case.
Second.
Okay. We have a motion and a second to deny the continuance request. Register your vote. Continuance request is denied, sir. And we are ready for our first case.
Item number 1, case number 13515, request of TLP Custom Homes for a variance to permit a single-family residence encroaching the 20-foot platted front building line located at 1532 Southwest 131st Street.
I apologize. One of the agenda items was a continuance request, so we would move item number 9 to be continued. My name is David Box, and I'm here on behalf of Dr. Douglas and Sandy Beal. Because of the unique nature of this case, it's an appeal from the HP Commission. We would prefer a full board. So we would ask that this body allow us a continuance to the next hearing.
Okay, we've got a request from the applicant on case number 9, 13514, for a continuance to March 1st.
Yes, sir.
Do I hear a motion?
Well, is there any objection from the HP? Well, then in that case, I'd move that we grant the continuance till the March 1st meeting.
Actually, there might be other people.
Oh, I'm sorry.
Anybody from the public that's with us today that has any objection to a continuance request on case number 9-13514? Hearing none.
I'll make a motion to continue item number 9.
To March 1st.
March 2nd.
We have a motion and a second. Register your vote. You are continued to March 1st.
Thank you very much.
Thank you. And do we have the applicant for case number 1?
I'm Tom Pollard at 3307 Hillview Drive, Norman, Oklahoma.
Speak to your application.
We built the house approximately 2 years ago, and we're about 2 feet over on a portion of the garage. We're encroaching onto the front building line. We're just trying to correct this for the home buyer.
And it's my understanding that this was discovered after receiving the certificate of occupancy.
Yeah, it was the mortgage survey. I mean, it was a couple days before we closed on the house.
Well, in that case, I'd move to approve.
Second.
Got a motion and a second. You are approved.
Thank you.
Item number 2, case number 13509, request of LM Real Estate Company for a variance to permit a building with exposed metal located at 7410 Northwest Expressway.
Your name and address for the record, please.
Malik Massid, 1010 Castle Road, Edmond, Oklahoma, 73034. 5 years ago, we got this approved for our Chrysler Jeep Dodge dealership with the new styles of automobile dealerships, and this one is for a Buick GMC dealership that uses the same style.
Can you speak a little bit to your hardship as what if we decide not to grant your application? Can you tell me?
How long do you have?
Well, not long.
Dealerships require us to follow their standards of new design,
Okay.
and if we don't, then they hold inventory and the whole deal, so we basically shut down.
So these are the dealership's guidelines as
It's
opposed
just the
to your
new
own.
metal paneling that's not corrugated, which is allowed.
If I'm correct, this is a sample of the material?
Yes.
Most of the dealerships now are using a material similar to that, I think.
Yeah, it's kind of the new thing. We're doing it on about 6 different locations.
Is there anybody in the audience protesting? Make a motion to approve.
Second.
I have a motion and a second. Register your vote. You are
Thank you.
approved. Thank you.
Item number 3, case number 13513, request of Callahan Steel Buildings for a variance to permit a building with exposed metal finish located at 12720 Oak Cliff Road.
Name and address,
Ben
please.
Brumley, 12720 Oak Cliff Road.
Speak to your application.
Yeah, the 2 buildings that you see up there already have the exposed metal siding on them, and so we want to stay uniform.
This is simply erecting another structure, similar construction to what's already there
Correct.
for maintenance equipment storage?
Yes.
Okay.
Yes.
I'll make a motion to approve the application.
Second.
I have a motion and a second. Register your vote. You are approved.
Thank you.
Thank you.
Item number 4, case number 13516, request of Elliott Architects for a variance to the landscaping and sidewalk requirement and to allow maneuvering in the public right-of-way located at 544 North Pennsylvania Avenue.
I'm Tim Grob with Elliott Architects, representing the owner,
And your address, please.
544 North Penn.
Okay.
Basically, they had a fire and half the building was destroyed. They just want to build back the basic footprint of what they had before and continue to use the parking that's existing now.
So essentially, restitution, restoring it to where it was. That's all
What it
we're
was
looking-
before.
Okay. Well, in that case, I'd make a motion to approve.
One question from the city standpoint, do we allow to have any money put up when we approve these to not put in a sidewalk, such as in the future, we might be able to use that money to put the sidewalk
Fee
in?
in lieu of type situation.
So there's none. Second.
We have a motion and a second. Register your vote. You are approved.
Thank you.
Thank you.
Item number 5, case number 13376 through 13381, request for use variance of Stevens & Johnson Operating Company for a permit to drill 6 oil gas wells located at 8601 through 8611 South Sunny Lane.
Mr. Walker, before you begin, I'd like to make a statement. Just go ahead and stand at the microphone, but I'd like to make a statement. It's, at our last meeting, we heard this variance request, and there were protests from the neighbors, and Mr. Stonecipher offered the opportunity for you all to visit outside of Chambers and to see if you could reach an agreement, and at the end of the meeting, you came back in, and the neighborhood representatives withdrew their protest request, and together you indicated that there was an agreement of the parties. We are back together because of a notification error, and there are letters from neighborhood representatives that indicate that there may not have been a meeting of the mind.
I
Yes.
think we had what was considered to be an agreement in principle, but we couldn't agree when we started writing it down. So that's, and maybe I'm mischaracterizing that. Maybe they'd like to characterize it another way.
And those folks will have the opportunity to, pardon me.
Mr. Chairman, I'm sorry, but at the board's previous meeting, the application was approved. So before you consider this, you need to have a motion to rescind your previous action.
But just for clarification, are we, as I recall, last week was with respect to that one particular well. Is that right? Or right?
Yeah, correct. That was a different application last week.
So then would we have to?
No.
Oh,
no.
okay.
Well, yes, these six, that was a previous, different application located just north of these.
Okay.
But yes, you would have to rescind your previous approval of these 6 and then rehear the case today.
Then a motion to that effect would be in order. Am I correct?
Yes.
So moved.
Second.
Motion and a second. The previous order is rescinded. Mr. Walker.
I'm Russell Walker. I represent Stevens & Johnson Operating Company. There's potentially a lot I could say about this, and I'm not sure exactly what you want to hear from me or what you want to hear from the protesters. I can say that on the screen is a depiction of the area in question. The 6 black dots inside the hashed rectangle are proposed well sites. The order that you rescinded was approved just almost exactly a year ago on February 17th of 2011. After that order was approved, what we call a pad was built, which is more or less in the area depicted by the hashed rectangle. I have various photographs that I could show. And the first 2 wells were drilled and placed into production. Those are the ones marked 80 and 81 on the screen. It was later discovered, and it first came to my attention directly after the meeting 4 weeks ago, the second meeting ago, when Ms. Talley called me at my office and said that there appeared to be a notice problem with respect to the residences in Bradford Place Estates, which is the cul-de-sac shown as Southeast 86th Place, just south of the land in question here. Apparently, those people had not been given notice by mail at their addresses of the hearings that occurred relative to these 6 variances a year ago that had been discovered, and Ms. Talley told me that we were going to have to give appropriate notice and show up at this hearing. And my understanding is that that appropriate notice has now been given. I think it's safe to say that we still have not come to an agreement with the owners of Bradford Place Estates. We think we've gone a long way, and they think we haven't gone far enough. So that's the summary of where we are now.
I think so, and I think we need to remember that you have a right to pursue your business interests, all the while being mindful of the impact of those people around you, and that for those of you in the neighborhood, you need to understand that he has a reasonable right to pursue his business interests while being appropriately considerate of your neighborhood. But I would also remind the neighbors that the square mile in which you live has a variety of other commercial and other businesses, and the experience that you're going to have living in that neighborhood is going to be different than a subdivision in which the whole square mile is developed residentially. So my request, and I think the solution is probably for some compromise on both sides. But for you neighbors in particular, be reasonable. This is not an opportunity to abuse an oil company. You have right to reasonable protections. You don't have the right to, just because they're an oil company, to abuse them or to hold them to an unusually high standard. So, in your defense, you have a right to pursue your business interests, and we're going to endeavor to protect those neighbors. We want to hear your concerns, and we want you to find a place where both of you can coexist. The neighbors feel like they've been heard. You feel like, that you've been treated fairly. One thing I would ask is, in light of, the fact that we are here and we're hearing some objections, and apparently the meeting of the minds that we thought was there is that we include some specifics of whatever agreement, if you do come to an agreement, that we incorporate those into the board order, and that way there won't be any ambiguity. I personally would not be in favor of leaving it to the discretion of the field inspector. I would prefer that, those issues be known to us and that we incorporate them into the board order. So, Mr. Walker, if I could excuse you, and we'll allow the other folks. Brady Smith is asked to talk. Name and address for the record, please.
300 Northeast 1st Street, Oklahoma City.
And a little louder into the microphone.
300 Northeast 1st Street, Oklahoma City.
Okay. Tell us about your protest.
I would first like to say that there actually was an agreement reached, and Stevens and Johnson backed out on the agreement.
Well, that we're going to characterize that as your opinion. Were you here at that meeting and a part of those conversations?
I watched the video online.
Okay. Well, the discussions that we're referring to took place outside of chambers, so there wouldn't be a recording of those discussions. But you're entitled to your opinion, but go ahead and proceed.
I got one question before he starts. Has the neighborhood and the oil company met since they met out in the foyer 2 weeks ago? Has there been any meetings at all?
There was
You'll need to approach, yes.
My name's Marshall Hugus, 4100 Southeast 86th Place, and at the last meeting, we stepped outside between the homeowners and the S&J company. We believed we reached an agreement. We shook hands and agreed that he would spell it out in writing and present it to the Homeowners Association en masse last week. Last Wednesday, he had said he would get it to us in writing on Monday. Last Wednesday, we were presented it by email and advised he would not be present at the Homeowners Association meeting, and what he ended up presenting in writing was very different from what we had shooken hands and agreed to outside.
So the answer to Mr. Allen's question is that no, you did not meet, but yes, you have corresponded?
We corresponded in that he notified us this was their new offer and that he would not be present.
Okay, thank you. Mr. Smith, continue.
As far as the agreement goes, I had communicated with Mr. Walker earlier this week, and the agreement that was sent on Wednesday was the only agreement that Stevens and Johnson would agree to, and like he said, it was not the agreement as agreed to. And we submitted a revised agreement that embodied the oral agreement outside of the hearing, and actually we're willing to compromise on the fence, as Mr. Walker advised the Homeowners Association that the fence would not be advisable because of wind and graffiti issues possibly with the fence. So the homeowners agreed that they would allow them to replace the existing trees with evergreen trees at a specific spacing. And the agreement was also revised. When I was watching the video, Mr. Walker informed me that they would pay $10,000 per each well on the land, on the 40 acres. And that was changed to $10,000 per well on the pad, which would be limited to the 6 wells. And regarding the February 17th, 2011 application of Stevens and Johnson, it appears that there was some misinformation contained in that application. They had stated that there was no development in the area, and I think, as we can see, that's not a correct statement. And the maps were shown, similar to the map that's on the screen right here, were shown without houses, but just the cul-de-sac road. And there appears that there was could have been some issues of tampering with that document. And I would like to also address the fact that they reneged on their agreement in the hall. And I think that just shows the kind of people that you're dealing with. They're dishonest, and they're dishonest here.
I'm going to stop you right there. I don't think that we want to get into, judging the character. I mean, you may disagree, but let's agree that we disagree on what we heard or what we agreed to without a personal characterization like that.
Okay.
I think it's clear without going on, it's clear to us that there is, some disagreement, that the neighbors have concerns, and I don't think any of us have an issue with that. What we want is for you, in your interaction with the oil company, to be responsible and act appropriately in terms of asking them. There are certain responsibilities they have, but they don't have responsibilities to just, dole out cash for everything that a neighborhood may, desire. And again, I'm pointing out to you that you live in a square mile where there is a variety of other commercial and other, businesses and development. And I want your neighborhood to stay good, and I want my neighborhood to stay good. But you cannot expect, that area to be the same environment as a neighborhood that is all residential without, other commercial encroachments and businesses adjacent to your neighborhood. You have business to your north, you have business to your south. There's another residential development right on Southeast 89th. FedEx is at the northwest corner of that square mile. I mean, there are a variety of other businesses on that. So be reasonable and be realistic.
For the record, I don't live in the neighborhood. I was retained legal counsel by the homeowners association to represent their interest here.
Mr. Chairman, I'd like to know what the agreement was out in the hall, and I'd like to know what has been reneged on. Let's don't go into a big rigmarole. We've already heard the case once. I'd like to know what was agreed on and what was reneged on so we can determine from that what we need to do.
And the only thing that I would hesitate to say is that, I don't know whether we want to get into parsing, every detail of an agreement between them and the oil company. What I'd like for them to do is to find a way, where they both agree for us to include enough specifics in our order. And that would not deal with any financial compensation or others. I think, we were advised that it not. And that as an act of good faith, the neighbors, act of good faith, Mr. Walker and his client, that, there's a common understanding. You all draft whatever document is appropriate and acceptable to both parties, where there's a clear understanding. Because it sounds to me, I don't think either party is malicious and, acted contrary to the good faith that it appeared to exist. But it's pretty obvious that, people weren't hearing or interpreting it the same way. So, write it down, be more concrete, let our order reflect those issues that were, landscaping, fencing, so forth and so on.
I would also like to address I do not think that Stevenson Johnson has presented sufficient evidence to be granted a variance. That is an R1 zone, and they have to prove specific things in order to be entitled to a variance. There's also a provision in the Article 3 of Chapter 37 that states that no well shall be drilled, nor shall any tank, batteries, well facilities, or equipment be located, and no permit shall be issued for any well to be drilled at any location which is nearer than 300 feet to any occupied or unoccupied dwelling. And there's a detached apartment at the address of, I think it's 3901. I'm not sure if you guys have this or not, if you want to pass it up to you. There's a map showing distances from would be the 5th and 6th.
I'd like to see that map. I'd like to see the map.
Okay.
Tell me about access to that detached apartment, because I've been in this neighborhood and all around this area. How does someone drive to that detached apartment? Is there a road back there?
No. It's a detached apartment similar to a detached garage apartment that you would see in Heritage Hills or some of the historic neighborhoods.
In your interpretation, because it could be used as a dwelling, that it's within, okay.
Right.
Any other issues before we hear the...
Is the requirement from the property line or the dwelling itself?
From the dwelling.
Okay, not the property line.
That's correct. It's from the dwelling, but a detached dwelling on that property would not be a legal dwelling.
Because it's not the residence address. The residence address is the primary house in the same way that a garage apartment would just... Am I correct? It's not the primary residence, and so, I mean...
Well, you can only have one primary. You can't have two residences on one lot. If that's a dwelling, it shouldn't be there. I'm sure it wasn't permitted.
So it may not be the issue that you...
I mean, it would probably be an extension of the primary dwelling. And also they have to show an unnecessary hardship before you can grant their variance. And a financial interest alone is not sufficient hardship.
And we will give them time to do that. Any other comments? Or we have a couple of other protesters that would like to
I'd like to
speak
make
to
a few more points. As far as the current well site and the way that it is landscaped, and they're not complying with Chapter 37 with the noise abatement, nor the site proofing requirements.
And I think that's been part of the discussion between the parties is to work out those issues.
And, you know, I would also say that this was bought and they knew it was an R1 zone. And they could have chose to drill a well on the north half of the south half of their 40 acres, on the north half of their south, on their 40 acres. And instead they chose to permit these wells without notice within, I believe it's 375 feet to the closest home, within 200 feet of the property line. So.
And that's a valid point. We'll ask Mr. Walker to address that. Thank you, sir. Next speaker, Tiffany and Scott Stevens. Pull the microphone down so we hear you nice and clearly, and your name and address for the record.
My name is Tiffany Stevens. My address is 3815 Southeast 86th Place in Bradford Place Estates. I typed up the 2 letters that I sent last Friday. And just kind of so you guys know, I work as a geologist at Chaparral Energy. I also have a law degree and have passed the bar, but I'm not practicing as an attorney. I just wanted to basically say that we've been trying to work out some agreement. We first found out about these wells when they were drilling them and not with proper notice, and I know you guys know that. Once they continued the hearing on the 19th, they did show up. We tried to work out agreement. They said, we'll take some suggestions. They wrote them down, sent us an agreement that following Monday. We felt, okay, we're starting to make some progress. You know, some of the things in the agreement I did not feel were very well written or very clear, and we wanted it to be clear what we were agreeing on, so we corrected some of those. We also looked at a decrease in property value because we feel we have substantial evidence that our home, as well as some of the others in the neighborhood, if not all of them, have a substantial decrease in property value. And we thought that that was part of the agreement, was to try to compensate for that. We realized once we talked to them again that they were not trying to compensate for a decrease. They didn't recognize the decrease in property value due to the drilling. And so we sent them a counteroffer the Wednesday before that February 2nd hearing, so on the 1st. Didn't give them a whole lot of time to look at, but we didn't have a whole lot of time to look at theirs and give it back. We heard from them as we were meeting before the hearing that they would not accept it. And we were like, well, is there parts of it you wouldn't accept, and which parts? And so when we went out to make an agreement out in the lobby back there, Mr. Walker clarified some of the things that I had tried to clarify in writing, and he said, yes, I intended that agreement to be this much per well on the 40 acres. And then, you know, we continued. We said, well, what about, you know, property value decrease? And he said, no. He pulled up some appraisals website and didn't feel that was justified, and we couldn't come to an agreement there, so we just moved on. We ended up saying, well, okay, let's talk about the fence. We just didn't feel that the trees that are out there now are doing any sort of, you know, site proofing. So they said they would be agreeable to maybe putting a fence up on top of the berm, but not the trees, because there wasn't enough room for both. We suggested trees in the backyard. They were agreeable to that. We felt we had reached an agreement. We moved on to our next issues, and so on. And then when we were done, we felt we had reached an agreement, so we withdrew our protest. When we got the agreement last Wednesday that was supposed to be the typed-up version of this, they had changed their mind on the fence, and I have a couple emails to that effect, but they had changed their mind on the fence for, I guess, wind and graffiti was the reasons that were given to us, and said that they would no longer do that. They said instead of planting trees in our backyard, they'd give us an allowance for that so we could plant our own trees. And I think we're okay with that, as long as we can try to do some sort of site proofing. One of the other issues was we didn't want to have to, they said if we're being inconvenienced from noise and nuisance, we'll pay $150 for you guys to go to a hotel while they're drilling. And we said, well, we don't want to have to, if we're spending 10 nights at a hotel, $150 a night, that's $1,500 out of pocket. We don't want to be out of pocket and then have to get receipts and then have to submit them. And they said, okay, well, we will give the hotel a credit card number so that we're not out of pocket. And we agreed on that. And then they've taken those, they took the fence out of the agreement, they took the credit card thing out of the agreement, they changed the language in the per well. I mean, there was a substantial difference in what was written. So we tried to, we basically, by this time, had talked to Brady Smith and Dick Gore and over at Mahaffey and Gore and said, we feel like the homeowners association as an association would like representation. So we did that, and they kind of took over typing up a counteroffer agreement, or typing up what we felt the agreement was.
If I may, just in the interest of time, let me go ahead and interrupt you at this point.
Okay.
I think we've got a sense of what your concerns are. Marshall and Catherine Hugus have asked to speak. Let's go ahead and hear them, and we'll give Mr. Walker a chance to respond.
Do you want to see this email of their explanation of why they changed the agreement? I don't know.
If you can, give it to
I'll
Kathy,
just
and she'll
pass it to
circulate.
you. Thank you.
My name is Marshall Hugus, 4100 Southeast 86th Place, and up front I'd like to say that if S&J was willing to step outside and iron out these, what I believe are probably fairly close differences, that the Homeowners Association would be more than willing to try and iron those out today, rather than walking away thinking we might have something in the works, only to find out later that we don't.
All right, and then do you have anything to add to the previous testimony, or in essence your concerns mirror?
Reiterating the noise abatement, during the last drilling operations, noise levels reached 95 decibels at the back door of the homeowners' residences, which would clearly indicate that there were no noise abatement measures taking place. And this was not just during daytime operations, but this was 24 hours a day for the duration of the operations. All right. Additionally, reiterate the visual abatement concerns, as well as the fact that there are 6 in such a small confined area. It's not like if there's one and then each one magnifies the effect of the others when they're combined in that close of a proximity. And that's a tremendous concern that they're putting 6 that close to each other right up against the backyards of the residences.
If I may, then let me excuse you, and we'll ask Mr. Walker and give him a chance to respond to your concerns.
Again, I'm not sure what you want to hear. I'm not sure that you want to hear about the money that was proposed to change hands. I'm not sure you want to hear about that. I'm not sure that's within the authority of this board. I'd be happy to describe our side of it if you want to hear that.
Actually, you're correct. I'm not really concerned about that. What I'm more concerned about is that you find common ground with the neighbors, if you can. And it's, Mr. Hugus is offering to request a, continuance to the end of the meeting so that you all can visit outside of chambers. If you would like, you may, request a continuance to the next meeting, or you may wish to proceed.
JJ, how many wells are on that 40 acres, do you know?
It's a fairly substantial field. I could research that and let you know. I don't know right off the top of my head.
We will go outside and have another conversation. There's one thing my client would like me to do, and that is to explain to you all that Stevens & Johnson has never tampered, nor have I, ever tampered with any document that ever went to this board, nor have I ever tampered with any document ever in my 40 years of law practice. And I have a pretty good reputation on that. And I think Mr. Smith's employers, who happen to be two of my best friends, would tell you that. And there's been no tampering with anything.
My name is Kim Gaines. I'm at 3901 Southeast 86th Place, so they're directly behind my house. I would like to request a continuance on this because, frankly, I'm tired of the Mickey Mouse back and forth sort of things, and being the last minute, which has been their character, it has been for the last minute to, get things to us and then back out of it and things of that nature. So I'd like to request a continuance if we could.
To everybody that's here in protest, that you refrain from these personal characterizations.
Okay. Okay, I can do that, but I'd also like to address, you talked about the other businesses that were there. They do not cause anything to us. We don't even hear them.
The point that I'm making to you is where my
Okay, yes, but they're along the edge, and this area is zoned residential. It's not like a zone commercial. We would have known that when we bought our house and had our house built. Back in the 60s. Back in the 60s. So... And, sir, we have been realistic and we have acted in good faith, and then they continue to back out. So now at this last backing out, I would like to have the time to get my information together and obtain counsel against this company because of these infractions of them backing out continually. So I would like...
The neighborhood has retained counsel, so if I could, let's let Mr. Smith speak for the neighborhood and whether you wish to take Mr. Walker's offer to visit outside chambers.
Okay, and can I ask you a question? What is your name?
I'm Jeff Austin.
Jeff Austin.
We've decided to try to work something out, continuance to the end of the meeting, step outside and try to get something.
And you're speaking for the neighborhood, and we have the neighbors.
Homeowners Association.
Okay. Mr. Walker, that's agreeable to you? Okay. We need a motion to move agenda item 5 to the end of the docket.
So moved. Second.
A motion and a second. Continuance is approved to the end of the meeting.
Item number 6, case number 13517, request of Superior Neon Signs for a variance to permit accessory attached signs exceeding the maximum allowed size located at 20 North Broadway Avenue.
Name and address for the record.
My name is Jim Gleason. I'm with Superior Neon Signs, 2515 North Oklahoma. We are proposing installing signs to identify the building located at 20 North Broadway, presently known as Devon Energy. Since the purchase of the building by Continental Resources, they've contacted our company to help them design a sign for the upper elevation. They've asked us that the signs be readable as the Devon signs and also be read from the new I-40 corridor, not the existing, but the new one. So what we did is we started with measuring the distance at 3,900 feet from the building to the new I-40. We determined at that time we needed at least an 8-foot letter height and set the letter C in Continental at that height. The artwork that was provided by Continental when we began was too narrow of a stroke. We had to bold up the stroke, and along with bolding up the stroke, we also increased the kerning, which is the space between the letters. We printed a banner, we dropped a banner over the wall, and we compared it with the existing Devon letters. We knew that the Devon letters were readable from a good distance, but we wanted the new Continental name to also be readable from the same distance. The existing letter height for Devon is 8 foot 5 inches as a lowercase letter. In our proposal, we're asking for an 8-foot tall letter, not even quite as high as the existing Devon letters. With all the alterations that we've made to the typeface and to the logo, we've also dropped the name Resources from their name to try to make this as visible as possible from a distance. The lower elevation, we made a recent revision to that, and hopefully you've got it in your packet. We were at 48 square foot. We've reduced that now with the new design down to 22 square foot to the lower elevations. I feel that Continental Resources looked at Oklahoma City to relocate because it is becoming an energy hub of the United States. They chose a building downtown for the exposure because they wanted to be seen. It is also very important to them to brand this building as their own. The greatest exposure on this building possibly is the upper elevation signs. We're not asking for a larger sign than what is up there now. We're asking for a sign that is slightly smaller in letter height. It just happens that twice the amount of letters in the new sign is what's in Devon.
I see the DDRC considered this today. Do we know what their position was at their meeting? Were you present?
Yes, they approved.
They approved it? Mm-hmm. Okay.
Right, it would seem to me that this is, you've got a larger trademark, and therefore you need a larger marquee.
It really, I mean, we tried to look at, we had this at one point within the code. We had the letters condensed, and we were shooting, I've got several photographs you'd like to see them. We were shooting from I-40, and it was just not readable.
Any objections that you're aware of to this at all?
No, not that I'm aware of.
Well, in that case, I'd make a motion to approve, or move to approve, I'm sorry.
I'm sorry, second.
We have a
I heard
motion
it,
and a
but I
second.
didn't respond.
We thought he was studying the issue in depth. Register your vote. You are approved.
Thank you.
Item number 7, case number 13507, request of David Ledbetter for a variance to the required number of parking spaces located at 1501 North Broadway Avenue.
Mr. Chairman, this is another case that was approved at a previous meeting, and to hear it, you need to rescind your previous action.
We entertain a motion to that effect.
So moved.
Second.
Motion and second. Register your vote. Previous action is rescinded. Mr. Ledbetter.
Yes, sir.
Your name and address for the record, please.
Dave Ledbetter, 2315A North Hudson.
Thank you.
As I said, we're here to hopefully get a variance granted for the parking requirements for our facility. The facility is approximately 9,700 square feet. We're required to have 98 parking spaces. We have 67 on site, to my knowledge. We were proposing to provide the spaces directly to the south of the property. The intention is to have fully valet parking. We have total control over that lot. The owner of the property required us to further develop the exit to the west side of the property as part of the terms of the agreement. We do not have to have that particular access open. We could put a permanent gate there. So all access in and to that parking lot would be from the existing driveway directly across from the facility.
Okay. If it's all right with you, I'll excuse you and allow some of the people that have come to protest your application.
And we have met with various homeowners, not the owner association. For Mrs. Mandel, we've offered to secure the property directly east of hers and give it to her to devote to whatever purposes she needs to.
Thank you.
Can I just ask Mr. Ledbetter one question? Can you tell what kind of establishment is it, just for clarification, because I've heard different things.
It's a restaurant. It's not a nightclub. They'll be offering fine dining. The proposed food service operator is well known within the city. They haven't reached a final contract. They hope to have done it today. There was a meeting at a venue in Yukon. The owner happened to miss the food service operator. They weren't able to come to an agreement.
And do you have any sense as to why people would think it was a nightclub? And of course I'll ask them, but
The writer for the Daily Oklahoman in his blog put up a post, and he basically insinuated it was going to be a nightclub and further insinuated it was possibly going to be a hip-hop club.
Okay. Okay, thank you.
Randy Ice, please.
Again, I'm Randy Ice, president of the Heritage Children's Neighborhood Association. We have not met with Mr. Ledbetter.
And if you would, just your address. For
119 Northwest 19th.
Thank you, sir.
Oklahoma City. Again, we have not met with the applicant. This area where the building exists is under our UCD ordinance, Urban Conservation District ordinance, which has been in place for over 30 years. It specifies that the parking should be to the east of the building. Okay, this parking is on northeast and south and even some to the west, which violates our UCD ordinance. It's also a problem for us. The property is currently zoned residential and commercial. There's adjacent use that's residential and commercial, and some of this parking will be right up against residential property. We believe it's a nightclub because it has a dance floor and a stage. I know he says it's going to be a restaurant, but we believe it'll be primarily a nightclub activity, and this is not compatible with immediately adjacent residential use. There's also an apartment building on the south side of the parking on 14th. We don't want parking back in the neighborhood. This is going to discharge cars back into the neighborhood at closing time. It's not compatible with a good neighborhood use. There's also a church on that block. St. Luke's Methodist Church has their youth building on that block. There are middle school children there in the afternoons and evenings, right across the parking lot for a nightclub. It's not appropriate, and I think that's fairly obvious. That's why we're opposed.
Mr. Chairman, just for point of clarification, but this variance is with respect to parking only?
That's correct.
Okay.
Debbie Blackburn.
And if you would, your name and address for the record, please.
Yes, Debbie Blackburn, 126 Northwest 22nd Street. First of all, we have not met. There has been no attempt to meet with the neighbors. The people who have met with the applicants have done it on their own, individually. I will say that, for one thing, as Randy pointed out, I have never seen a restaurant that has a dance floor and a stage like this. You usually do not have that. We've heard every kind of thing, and it's dangerous when you're being asked to pass variances to allow something that will be there for perpetuity. I can also say that the owner of the property, these people are just going to lease this property, is a very well-known slumlord in the inner city. In my 35 years of trying to fight for this neighborhood, The particular property owner has been the cause of a lot of dismay for a lot of neighborhoods in the inner city. These people are not going to own this property, but it sets a precedent. And as I said, if you all can think of a restaurant that has a dance floor in this kind of a layout, we do have a church there. If the license, I have spoken to the Able Commission, the applicant has now begun to say, oh, this is a restaurant, it's not primarily a bar. You know, if you just sell $1 more in food than you do in alcohol. And the Able Commission says they're having difficulty with groups like, I don't know this particular, but with a lot of people that are coming in for applications that morph into a full-fledged bar at night, and they offer a lot of food in the daytime. What I'm asking you, and I know it's not common for the Board of Adjustment to go back on a decision they've already made, but I think you realize now that we were not aware of what was going on here, and this has a lot of implications. If those curb cuts and those variances are allowed, which I know that is what you're here for, to allow those variances, but you also, as you well know, do not have to allow something that would violate zoning rules that were put into effect to protect that parcel, the first suburban area of Oklahoma City, which, although we fought for some 3 decades for this, ever since George Shirk found out that the Department of Transportation wanted to put a highway up 16th Street, it's been a battle forever to maintain that. And if you have something like this, it will violate state law, ultimately, if they don't get the right kind of liquor license, because they are within 300 feet of St. Luke's Youth Center in the old Heritage Association Book Center there on the corner of Robinson and 14th. So I would respectfully request that you think very carefully about allowing these curb cuts and variances that would pour traffic onto 14th Street and affect a church and the neighbors and pull us backwards into something that we thought we had. It doesn't matter to the neighbors whether it's a hip-hop club or a honky-tonk two-step. That's irrelevant. So I thank you for your time, and I hope that you will consider this, even though you have already made a judgment previously that we weren't aware was being requested, that you not let that stand in your way.
And we have rescinded that order, too, so thank you very much for your comments. Bernadine Madole, please. Your name and address for the record, please.
Thank you. I'm Bernadine Madole. I live at 2325 North Youngs Boulevard, but I own the building on the southeast corner of Northwest 14th and Robinson. I've been there for 40 years, so I'm very acquainted with what goes on there. I'm looking at the staff report, and I see that the reason for this request for the variance is a hardship on the proposal for this so-called restaurant. I would submit that the hardship has been made by the applicant himself. If they revised their plans and stayed on their own land, they wouldn't need this variance. The fact that this is going to accommodate 360 to 375 people means that it's a large operation. Why David Ledbery, I always have trouble with his name. I've been to see Letterman. Yeah.
Ledbetter, yes, Mr. Ledbetter.
Thank you. Why he thinks people really want valet parking and be convinced that they can control that lot simply because they want it to happen is a mystery to me. If this place gets to be successful and people are drinking from 11 in the morning till 11 at night or until 2 in the morning, And if this is successful, we're going to be overwhelmed with cars all around the neighborhood. They're not going to obey, no matter how much this restaurant wants them to go into this lot and out of this lot in one space. That means all of the property around is going to be at risk for damage, for trash, for noise. Now, 78 cars in the middle of a space that's bounded by the lofts, the garage apartments, my building, a residence that is now vacant, but the owner wishes to reestablish as a living space. All of the people who live to the north in that block, including the Aberdeen, they're going to be affected all night long with cars coming and going, trash, noise, what have you. When people have been drinking, I'm sorry, I can't see that this is not going to be a nuisance. There's one fact that I'm very aware of because I've been there for such a long time, is the traffic pattern. If the exit onto 14th Street, if they're encouraging that, you have a choice of turning right and going to Broadway. You have to cross a very busy lane of traffic to get going north to the highways, and I'm assuming that's where most people at night would be heading. If you turn left and you don't know the area, you will come to 14th and Robinson, and again, in order to get to the highways, you turn right. But that's a one-way street going south. So I think there's a big potential for traffic problems, accidents at that location. My building over the years has been hit twice because of traffic problems at that corner. People hit each other and the cars spin off into my building.
And could I just clarify, is the building you own the one that's labeled Art Gallery?
That's me.
Okay.
That building looks vacant, but I can assure you, I'm there and we're working. I'm retired, but artists don't really retire. So I'm not a business at this point, but I'm there daily. And I know this neighborhood, it's quiet at this point. People are free to jog in the evenings now without much problem. People walk, older ones, younger ones, take their dogs. This is a residential area with a church, and nobody has mentioned the hospital, which serves very severely ill people. If they look out their window, they can see this proposed parking lot. They will be affected. Thank you.
Thank you for your comments. Is there anybody else from the public that wishes to speak in support or in opposition? Yes, sir. Name and address for the record, please.
Alan Kirkpatrick, 421 Northwest 18th. I'm a resident of Heritage Hills. I'm a member of St. Luke's United Methodist Church. My son goes to daycare there, and every day I drive south on Broadway, I turn right on 14th to go pick up my 13-month-old son. From a design point of view, as a design professional, I don't see how this is consistent with anything in the area. From a personal point of view, I really don't want to look forward to going down 14th Street at 5:30 and hitting happy hour. I did meet with David Ledbetter. It was on my own. I contacted him twice, and we finally met. And I'm unconvinced that the restaurant has a direct or a solid direction, and that obviously is a little bit of a concern. So I'm definitely opposed to the variance.
Thank you for your comments. Anybody else wish to speak in favor or in opposition of this application? Mr. Ledbetter?
Mr. Chairman, I might point out again, and maybe for the protesters, that the actual zoning for the ABC2 will be at the Planning Commission on February the 23rd.
And what the matter that's before us today is a variance request on parking. And I think, the concerns that are expressed for the neighborhood are valid, and when I look at the layout inside the building, I continue to be concerned because it looks like, there's a lot of opportunity in a lot of places that are not designed for dining, but are designed, to view the entertainment, whatever it may be, and to, have an adult beverage.
Okay. The only thing I would ask today is for the continuances, which we would request, and it's time to explain to the surrounding neighbors and associations what the full intentions are.
And unfortunately, your continuous request has already been denied.
May I ask another question? It's probably addressed to the zoning. We're able to legally operate a facility within the required number of parking spaces in that particular area. Am I not correct? If I were to partition this off to 6,000 feet, I have 67 parking spaces. Whether or not they have liquor offered or not, they could legally operate a restaurant there.
That's correct.
But still he has to have the parking though, right?
Has to have the available parking.
Yeah, he's asking if he made the restaurant smaller to where he met the parking, he could operate a restaurant there.
And would the owner or any developer of the property to the south be able to legally operate a parking lot whether or not that parking was required for that facility or not?
That's correct.
If the ABC2 is passed by the Planning Commission.
And whether or not the ABC was operated, the intent of the developer is to proceed forward with this, in whatever manner possible. And hopefully, in my opinion, an ABC2 restaurant must be preferable to other operation. It has a higher status and higher quality.
Ready for a motion? I think the parking is more than 50% over what the parking requirements are for the city, and I would make a motion to deny the request.
Have a motion?
I will second.
We have a motion and a second to deny. Your variance request is denied, sir.
About a break.
Chairman authorizes a break, a 5-minute recess and break.
from decisions. If there's a dispute over an interpretation of the zoning ordinance, the Board of Adjustment hears that. I should say there's actually 4. The board also hears appeals from other boards and commissions, HP Commission, DDRC. They hear special exceptions, which are uses that are allowed subject to approval of the board, and they hear variances. That's what you're here on. And the variance is an excused violation of the code, basically. If somebody, for whatever reason, can't comply with the code, they can come to the Board of Adjustment and request a variance from that provision.
So basically mainly just with property, structures,
Mm-hmm.
things of that nature.
Right.
I'm learning more about you guys than I ever wanted to know. But I like your building. It's a nice.
Well,
like the Art Deco lamps and.
Are you eager for us to return?
as soon as JJ comes back, we'll reconvene and
Ready? Okay. You're not going to believe this, but I think in 60 seconds, we're going to have a real honest-to-God agreement that everybody agrees to, that we don't have to go rewrite someplace.
We'll wait on you. I'd like to reconvene Board of Adjustment meeting for February the 16th. Mr. Walker?
I think it would be safe to say that we have an agreement that we don't have to go rewrite someplace or propose to somebody. We had actually sent over an agreement, and I think we've agreed to 3 changes in the agreement that we sent over, all of which are clear and understandable to both of us. And then, that having been said, then I think that we could announce no protest. Is what I said accurate?
I would like to... Your name and address for the record, please.
My name is Scott Stevens, 3815 Southeast 86th. I would like to suggest that we discuss briefly the points of the agreement. 2 weeks ago, we had a verbal agreement as well, which was changed. So I would like to at least discuss them briefly.
I think, what we would like to include in the board order is the issues that are relevant to the surface. Am I using the correct terminology, JJ? But, any financial, agreements between you should not be included in the board order, would not be appropriate. But just expeditiously, if you would, just highlight the
first change, or the first modification, was actually in the proposed agreement, but it was an addition that the evergreen trees will be a minimum of 8 feet in height and a distance of 1 foot from the narrowest points between the 2 trees. And they're going to leave the... I know, that's what...
Okay, that's, keep in mind, we've told you it's our agreement, and that is not in our agreement. What we said is we will plant evergreen trees on the north side of the existing trees, and we'll say so they'll make a solid wall on the north side of the existing trees.
So without spacing requirements, not it. Is that what you're saying?
Yes, we'll plant them so that they make a solid wall when they fill out. But again, this is our agreement, not the one they changed.
One second. misunderstandings, The agreement would be as it was submitted by them, with the change, or the understanding in paragraph 1A, that they will plant evergreen trees on the north side of the existing trees to form a solid wall sufficient to screen the well site.
You're not going to specify a specific spacing, you're just going to specify...
That's how we did have the spacings, but that was kind of our misunderstanding on the portion of it.
Sure.
On the north side.
The landscaping shielding is actually on the south side. It would be on the north side of the neighborhood, the south side of the well sites. Am I correct? Okay.
As they grow, they will form a solid visual wall between the residences and the pad.
If you have that common understanding, we just want to insert some language into the order that indicates what you've agreed on.
Is our common understanding, is it not?
With the understanding that the new plantings will fill out and create an appropriate screen.
A site-proof screen.
That's right. The new plantings don't necessarily fill in every space, but they're plantings that grow fast enough and will.
Coincidentally, we've also said that if any tree dies, we'll go out there and get it out and put a new one in there. We really had to do a lot of watering this summer on those trees that we planted this summer. We'll do the same thing with these to try to keep them alive. If one dies, it'll be taken out and a new one will be put in.
Okay. Mr. Smith, what's next?
In paragraph 3 of the agreement, the language will stay the same with the exception of there will be a $10,000 compensation for the Vinkel 1 or the Vinkel 26 well, I believe. It's right northwest, the one that you guys heard.
And again, these go ahead, Dan.
That's not appropriate for the board order. That's between you and the operator. The board can't require them to perform any kind of compensation,
Right.
monetary compensation.
I was just reading in the...
That's one of the changes
Right.
being made from the way I wrote the agreement to add that Vincent well to the number of wells that they would pay the homeowners.
And I think our position is those are agreements between you. What we would just like to insert in the board order is anything related to the landscaping, screening, those sort of things. And then we would, I think, be prepared to go ahead and act on your request.
I believe that is the only...
Okay. The rest of it deals with...
I want to hear a couple other changes. I had written an arbitration provision into the agreement so that if we got in a dispute, it would be arbitrated. That's been taken out and put a litigation provision has been put in. That's one of the other changes we made. There were...
Well, I don't believe
those were the three we made.
And again, those are agreements between you all. They won't be part of the board
The only
order.
reason I'm saying is this, that they were using the agreement that I sent over with the 3 changes that we've just reiterated that haven't been written yet, but we'll know what they are and we can stick them in here.
But just, I'm just, and this is just me, I don't know if the board agrees, but I'm just curious with respect to the major points on the fence, the trees, and, just the facts that, or the points that, the reason that we're here. The other agreements, that's fine, that's a private contractual thing, but I'm curious as to what our order needs to say. What I have here is my understanding that 8-foot evergreen trees, 1 foot apart in spacing. That's not? Okay. That was something that was on the north of existing trees and berm to create a wall, and also with the agreement to maintain and replace if necessary.
I think the order would state, that the proximity is such that it, that the evergreens would fill in an appropriate landscape barrier or something to that effect. Is that appropriate?
Yes.
Okay.
Yeah, it's just sufficient to site-proof the area.
And then all we want to hear from you, Mr. Smith, and from you, Mr. Walker, is that you have agreement, and are you in a position to withdraw your protest?
I believe I am.
Thank you very much. Mr. Walker, any other business before us, before we
No,
act
sir.
on your...
I guess we're going to have to go through each one individually. Do we do that?
I don't think so.
I would say I withdraw my protest, contingent upon us actually getting this signed, just to make sure that we get this agreed to and there's no other hiccups on that.
But now that doesn't relate to your board order. If we approve the variance request and you tell us with Mr. Walker that you have an agreement, it's up to you to get it signed, and we are not a party to that agreement.
That's correct.
I just would.
As long as you two gentlemen are of one mind.
And we could, if that's the case, we'll go through here and we can just run an initial on it right now before he takes care of his business, or to keep you guys from your time, we'll do it afterwards if that's.
If you want to take a moment, and if they're willing to do that, that's fine, but we need to go ahead, and we're ready to act on the request.
I'd like to ask one question. Is the resident here that has the house where it says a detached apartment? A what?
She left after the.
I'd like to request that the city look into that and see if that in fact is a detached apartment, because it would be illegal if it is, if I could do that.
No, that'd be fine. I would ask Mr. Walker and Mr. Smith if their business together is concluded and whether you're ready for a board action. Okay, we're still in the process.
The president of the Homeowners Association is going to sign, and then we will be done.
Thank you. Yes, sir. Is your business together complete?
I believe it is.
And you represent the Homeowners Association, and they've withdrawn any protest?
That's correct.
Thank you. Mr. Walker, anything else before the board acts?
We're hoping that you will reinstate the variance granted in 80 and 81, again, because those wells have already been drilled. We don't want to be in any kind of even technical violation if that's possible. Pardon me? Yeah, there are 2 of the 6 that have already been drilled and placed into production. We just want to make sure we're not in any kind of technical violation, however that would be done.
So when the board votes today, then you are covered, is what I'm hearing?
Yes.
Okay. Okay. Does that answer your question then?
I think I heard it, but I hate to say I'm not really sure.
Dan or JJ, would you elaborate for him?
Once the board votes to grant the variance, all 6 and the 2 you're specifically asking about are covered.
Thank you.
At this point, we're ready for a board action. Would entertain a motion.
Move to approve the application. Conditioned upon the, I believe, 8, and I'm happy to amend this, but 8 feet evergreens on the north side of existing trees and berm to create an eventual site-proof barrier.
I believe we have a correction.
Do we have a correction?
Yeah, the 8 foot you need to delete.
Okay. Happy to accept that.
So the board order should read that evergreens planted on the north, exposure of the site.
There's a berm that we actually built there. They'll be on top of that berm.
That the evergreens will be planted on the top of the berm and to be planted with spacing as such so that it provides an appropriate screening of the well sites.
Yes.
Would that be proper? Okay. Let's use
Accept.
that language.
Yep.
We have a motion.
Second.
Motion and a second. Register your vote. Are approved.
Thank you all very much for being patient with us.
Well, and thank you, to the representatives of the neighborhood and Mr. Walker and your the firm that you're representing for working with us. Thank you very much.
Mr. Chairman,
Motion to adjourn.
Adjourn.
We are adjourned.